My name is Aaron Goodman, and I'm a partner in litigation and government enforcement in Baker McKenzie's Los Angeles office. I want to talk to you today about employee activism and whistleblower protection. Employee activism and whistleblower protection continue to increase. Where protections exist, whistleblowing usually trumps trade secret rights, so whistleblowers may be immune from trade secret liability. So the question is, should organizations be concerned? And secondly, what can they do to protect legitimate trade secrets? Here are some of my top tips. It's worth remembering that having a genuine speak up culture is beneficial. It unearths potential problems, meaning they can be resolved at the time. It can also avoid external whistleblowing, helping preserve trade secrets. Next, understand what legal protections exist in the jurisdictions where you operate. There is a patchwork of protection globally, so different rules apply. There has also recently been an increase in protection with EU member states, which requires internal reporting channels and gives protection against retaliation. And although those rules only apply in the EU, they can impact a US parent company's whistleblowing channels and obligations. The main plank of whistleblower protection is a prohibition on retaliation, but it can make a real difference to know the precise scope of protected activity. For example, in some jurisdictions, protection for whistleblowing to the media might be limited. In the UK, employees usually first have to blow the whistle internally or to a prescribed regulator. These mechanisms enable organizations potentially contain any disclosure of trade secrets. If a whistleblower starts litigation for retaliation, there is a risk that information will come out in open court. And one thing we commonly see is that a whistleblower wants to prove they were right about the alleged wrongdoing they have reported. But litigation about retaliation usually doesn't require proof that they were actually right or that the employer took adequate remedial steps. Therefore, the scope of information to be revealed in court can be curtailed. In addition, in some jurisdictions, it might be possible to obtain a protective order restricting the reporting of some information. In the US, we have schemes to incentivize whistleblowing to certain regulators. However, this does not give a whistleblower an unlimited right to retain documents containing trade secrets. Once they have provided materials to the regulator, the organization could be entitled to delivery of the confidential documents. Finally, however, be smart about PR optics. Clamping down on a whistleblower, even if legally entitled to, might cause negative reaction both internally and externally.